of lectures entitled Law and Transition. In recent years, privilege in civil cases has been the subject of significant development in the case law, and further changes, which I will attempt to explain, will be brought about by the new rules. And let me say that I'm most grateful to Mr. Justice Morden for having allowed me to have access to the new rules so that my remarks today could be prospective rather than just retrospective. And of course, you'll be hearing more about the new rules from Professor Watson. In examining these developments, I'm going to try to do two things. First, I will try to identify what seem to me to be the important underlying principles and theories which are at work. It's my belief that the content and direction of a doctrine in a developing area such as this can only be appreciated in light of careful analysis of principle and policy. Secondly, I will endeavor to link my discussion of the specific rules governing privilege with a consideration of the process of discovery as a whole. For it is also plain that the courts are dealing with more than abstract theories, and that the rules they develop will be functional and process-oriented. In particular, I'll examine those aspects of existing case law and the new rules which do not alter the formal definition of privilege, but which in practical terms, I suggest, will substantially reduce its scope. Now first, if I may attempt to define my subject more closely. A rule of privilege permits a party to conceal material that is relevant, and to that extent bars the court from having access to material which might affect the result, and therefore impedes, if you like, the search for the truth. The basis of that is that other interests are more important. Now, there are many sources of privilege, and you've just had the benefit of Mr. McDougall's able exposition of two of these. The rules he has considered operate the same at trial as on discovery. The effect of the successful assertion of a claim of Crown privilege or solicitor-client privilege will prevent the information from ever coming to light, whether at discovery or at the trial. Now, of particular interest at the discovery stage, and the focus of my remarks today, are the rules which protect material prepared and gathered in anticipation of litigation. And one of the problems here is labels. Various labels have been used, and as Mr. McDougall did mention, not always used consistently. And I'm not one who likes to invent new labels, but if you'll permit me, I'd like to use the label, the litigation privilege, for the type of privilege that I want to describe, because I think it is important to make distinctions between other sources of privilege. A definition of litigation privilege, which is often quoted, is that given in the case of Wheeler and Lamarchand, which was a decision of the English Court of Appeal in the late 19th century, where the following was said: "The case is no doubt established that documents are protected where they have come into existence after litigation commenced or in contemplation, and where they have been made with a view to litigation, either for the purpose of obtaining advice as to litigation, or of obtaining evidence to be used in litigation, or of obtaining information which might lead to the obtaining of such evidence." Now, this rule protects, then, at the discovery stage of an action, investigatory or preparatory work relating to the investigation itself. Because much of this material will be actually used at the trial, that's the very reason it's brought into existence, the successful assertion of a claim of litigation privilege will often only have temporary effect. In a pragmatic sense, litigation privilege permits a party to shield from disclosure at the discovery stage material which, if favorable to that party, will be used to that party's advantage at the trial and to the surprise of his opponent, and which, if unfavorable, will be buried from sight and never revealed at the trial unless the other side has some other way of getting at it. Now, because we favor neither surprise at trial nor the suppression of relevant information, there has been an understandable tendency to shrink the scope of privilege. Before I examine the rationale for the privilege and consider how wide it is or is going to be, permit me to make one further distinction which I suggest will help understand this subject. In my submission, it's critically important to distinguish litigation privilege from solicitor-client privilege. There are, I suggest, at least three important differences. First, solicitor-client privilege applies only to confidential communications between the client and his solicitor. Litigation privilege, on the other hand, applies to communications of a non-confidential nature between the solicitor and third parties, and indeed will include material of a non-communicative nature. Secondly, solicitor-client privilege exists any time a client seeks legal advice, whether or not litigation is involved. litigation privilege, on the other hand, will apply only in the context of litigation. Third, and for my purposes today the most important, I submit that the rationale for solicitor-client privilege is very different from that which underlies litigation privilege, and that this difference merits close attention. The interest which underlies the protection accorded communications between a client and a solicitor from disclosure is the interest all citizens have to full and ready access to legal advice. If an individual cannot confide in a solicitor, knowing that what he says will not be revealed, it will be difficult, if not impossible, for that individual to obtain proper advice. Litigation privilege, on the other hand, is geared directly to the process of litigation. Its purpose is not explained adequately by the protection afforded lawyer-client communications, the interest protected by solicitor-client privilege. Its purpose, the purpose of litigation privilege, I submit, is more particularly related to the needs of the adversary trial process. Litigation privilege, I suggest, is based upon the need for a protected area to facilitate investigation and preparation of a case for trial by the adversary advocate. In other words, litigation privilege aims to facilitate a process, namely the adversary process, while solicitor-client privilege aims to protect a relationship, namely the confidential relationship between a lawyer and a client. Now, relating litigation privilege to the needs of the adversary process, I suggest, is very important. The effect of a rule of privilege, as I've mentioned, is to shut out the truth. But the very process litigation privilege is aimed to protect, the adversary process, amongst other things, aims to get at the truth, so that we have competing interests when a claim of litigation privilege is asserted. On the one hand, there's a need for a zone of privacy to facilitate adversarial preparation. On the other hand, there's a need for disclosure to foster fair trial. Now, I would suggest that despite the push towards more and more disclosure in pretrial discovery, the adversarial nature of our process must be kept in mind. We have, I think, a firm and unfailing belief in the strengths of the adversary system, and we continue to rely on self-interest, party motivation, party investigation, and party presentation at trial as being the best methods to get at the truth. Our commitment to the adversary system means, I suggest, that despite the unmistakable and unrelenting trend towards more complete and open discovery, we need a more principled and thoughtful approach than simply saying the more discovery the better. On the other hand, our belief in the adversary system is not unqualified. More and more we deprecate its excesses, and increasingly we hear judges encouraging, through our discovery process, disclosure and openness. I suggest that the concepts which underlie the rule of legal professional privilege are an attempt to reconcile these competing and at times contradictory forces and arguments. Now, when we look for the rationale for litigation privilege, we find various things have been suggested. Sometimes the privilege has been explained in terms of the sporting theory of justice. I would suggest that this is the least compelling argument to support privilege. The argument that asserts that an adversary trial depends upon surprise, and which argues that disclosure is the enemy rather than the friend of truth, I think is quite outmoded. So although this theory, the sporting theory, has a long history, I suggest that it's out of keeping with the modern view which favors greater pretrial disclosure. And I will argue later, both case law and the new rules make it quite clear that the surprise theory has been discarded. Another argument, however, might be that the adversarial incentive to investigate will be impaired if litigation privilege does not exist. A party might refrain from conducting a thorough examination or investigation, hoping to borrow on the work of his opponent, or perhaps more likely to refrain from fully investigating delicate areas where unfavorable information might be uncovered. Counsel might fear that pursuing an investigation in a sensitive area, if the fruits of such research, favorable or unfavorable, had to be disclosed to the other side. However, I would suggest this argument proves a bit too much, because discovery rules have long forced disclosure of unfavorable as well as favorable information, and they don't appear to have destroyed the spirit which underlies our adversary process. The risks of not investigating are simply too great. I would contend, and I hope to be able to show, that the most convincing rationale for the protection which is covered by litigation privilege is that suggested by the work product test. And I would also suggest that this work product analysis, in fact, is the best description of the interests that we now protect and that we will protect under the new rules. Now, although the phrase work product is only rarely employed by Canadian courts and it's not contained in the new rules, I argue that implicit in the scheme for discovery that we will have, and to some extent now have, is an acceptance of the basic tenets of work product doctrine. The work product test was first enunciated in the leading American decision of Hickman and Taylor, decision of the Supreme Court, where production of witness statements taken by the lawyer for one party were sought by counsel for the other. Now, the witnesses in question had already testified at an investigatory hearing. The content of their evidence was discoverable under federal court rules, and indeed they could have been interviewed by counsel seeking production of their statements. So not surprisingly, the court asked counsel why did he want them, and his answer was very candid. He said he wanted this information to help prepare himself to examine witnesses to make sure he hadn't overlooked anything. In other words, he wanted to see what the other guy's theory was. Mr. Justice Murphy, delivering the opinion of the court, held that production could not be refused on grounds of solicitor-client privilege for the reasons that I attempted to give earlier, this was not a direct communication between the lawyer and the client. However, Mr. Justice Murphy went on to say that there was another policy directly related to the litigation process which could be invoked to protect the information in question. And this is the policy which I suggest best captures the rationale for litigation privilege. And I'll quote Mr. Justice Murphy's, from Mr. Justice Murphy's judgment. He said, "Historically, a lawyer is an officer of the court and is bound to work for the advancement of justice while faithfully protecting the rightful interests of his clients. In performing his various duties, however, it is essential that a lawyer work with a certain degree of privacy, free from unnecessary intrusion by opposing parties and their counsel. Proper preparation of a client's case demands that he assemble information, sift what he considers to be the relevant from the irrelevant facts, prepare his legal theories, and plan a strategy without undue and needless interference. Were such materials open to opposing counsel on mere demand, much of what is now put down in writing would remain unwritten. An attorney's thoughts, heretofore inviolate, would not be his own. Inefficiency, unfairness, and sharp practices would inevitably develop in the giving of legal advice and the preparation of cases for trial. The effect on the legal profession would be demoralizing, and the interests of clients and the cause of justice would be poorly served." Now, in my view, this analysis identifies in sharp focus the interests which our courts are trying to protect through litigation privilege. The adversary system depends on careful and thorough investigation and preparation by parties through their counsel. The adversary advocate cannot prepare without the protection afforded by this zone of privacy. So our rules of discovery and privilege must strike a delicate balance. On the one hand, too little disclosure will impair orderly preparation. Counsel cannot come to trial prepared without some idea about what the other case is going to be. On the other hand, going too far towards total disclosure would be demoralizing and would impair orderly preparation. Thorough investigation and careful development of strategy would be discouraged if every thought and observation had to be disclosed. The work product test focuses on the need to protect counsel's observations, thoughts, opinions as the core policy of the protection from disclosure of preparatory work. As I've said, it's my thesis that although the case law developments and the new rules for the most part leave intact the formal definition of our litigation privilege rules, the net effect of the changes we have already seen in the cases and those we're about to get in the new rules is that the actual content of litigation privilege will be best captured by this concept of work product. Now, permit me to attempt to apply and develop these general points more concretely. Although it was decided 10 years ago, and although the point established is hardly startling, a useful starting point is the judgment of the Ontario Court of Appeal in Perini Limited and Parking Authority of Ontario. There it was held that in modern discovery practice, there was no place for the English rule which permitted a party to an action to refuse to produce documents relating exclusively to his own case and not supporting or tending to support the case of the opposite party. Now, in retrospect, it perhaps seems odd that it would take the considered opinion of the Ontario Court of Appeal to establish that point. but I would suggest that we can still learn something from this case. In the judgment, their lordships were at pains to explain the need to relate traditional English rules of privilege which we've inherited, to modern Ontario discovery practices, which are really much more American in their approach, particularly in that the central feature of our discovery process, the oral examination, does not even exist in England. The court reasoned that as information relating to a party's own case was clearly discoverable on oral examination, it made little sense to continue to apply an English rule to protect documents which fell into that category. In other words, it makes no practical sense to talk of documentary privilege without taking into account the fact that that same information can be garnered on oral discovery. Now, already, I would suggest there are important aspects of documentary privilege which are significantly qualified by our rules of oral discovery. It's well established, for example, in the case law, that where a party on discovery is asked for facts relating either to his case or his opponent's case, those facts must be revealed, notwithstanding that the party's source of information is a privileged report or document. The party does not have to produce the report or the document for inspection, but must give the facts that emerge from that report. So the net effect of the rules, is to shield the document itself and hence leave undisclosed the identity of the maker of the document and the actual evidence or opinion or expertise which may be contained in the document, but the facts themselves must be revealed. Now, the significance of this qualification on documentary privilege will be considerably increased by the new rules. Under present case law and rules, a party is entitled on oral discovery to refuse to answer the questions, who are your witnesses, and how are you going to prove your case? Existing rules distinguish facts from evidence for the purpose of discovery and require only disclosure of facts. Now, the case law, of course, has recognized that this is a subtle distinction, and there are situations where the courts have said we must err on the side of disclosure. Nonetheless, there is that distinction. The new rules will abolish the need to distinguish between fact and evidence for the purpose of discovery. They expressly provide that on oral discovery, a party can be asked to disclose evidence, and that the names and addresses of persons who might reasonably, I'm quoting the rule, the names and addresses of persons who might reasonably be expected to have knowledge of the transactions or occurrences in issue in the action must be disclosed unless the court orders otherwise. Now, that doesn't affect the formal definition of privilege, but clearly it's going to have a substantial impact upon the scope, the practical scope of privilege. A party's evidence is the material that he and his lawyer have gathered in preparation for the litigation, and hence the old rule against forcing disclosure of evidence was closely related to the protection afforded by litigation privilege. The rationale which permitted a party to refuse to disclose the identity of witnesses or evidence is, I suggest, a dubious one in light of the rest of our discovery practice. And I further suggest that its rejection in the new rules is best explained by work product analysis. Permitting concealment of evidence appears to be based on the argument that the less one side knows about the other's case, the better. And some of the old cases, as you know, put it on the basis that surprise at trial is the best antidote to perjury and witness tampering. The predominant modern view, however, is that surprise at trial is the enemy rather than the friend of truth, and I suggest that the provision in the new rules which forces a party to disclose evidence is fully in keeping with this thinking. Quite clearly, this development, as I've said, will have significant implications for the traditional view of privilege. The result we're left with is that the formal rule of privilege, which is intact, will permit a party to refuse to produce witness statements, reports, other documents gathered in anticipation of the litigation. But the actual effect of that rule is going to be reduced by the oral discovery rule, which will require disclosure of the evidence contained in those documents. When you consider what's left, I suggest that it's something that comes very, very close to what the Americans have described as work product. Once the evidence contained in the privileged document is revealed, there's little left that's undisclosed except for something very important, and that is the thoughts, opinions, observations of counsel. Now, if I could turn to the question of expert reports, one of the most significant areas concerning litigation privilege is that which deals with expert reports. Again, here, the new rules will make significant changes which for the most part don't affect the formal definition of the privilege which attaches to such reports, but again, which will substantially reduce its practical effect. Existing Ontario practice does not require a party to provide his opponent with an expert report prepared in anticipation of litigation, even where that party intends to call the expert at trial. Now, of course, there's a statutory exception in the case of medical evidence under the Evidence Act, where notice that the doctor is to be called and a copy of the report must be given shortly before the trial as a precondition of the doctor's evidence being received. I submit that the case for a rule which would require disclosure at the discovery stage of all expert evidence upon which a party intends to rely at trial is very strong. The difficulties of preparing for trial or even preparing for settlement discussions in cases which involve evidence of experts would be clearly alleviated by requiring disclosure. Permitting a party to conceal reports at the discovery stage has the effect of permitting that party to surprise his opponent at trial with expert evidence of the most difficult sort to be met with by surprise. And as I've tried to indicate earlier, surprise at trial is now generally seen as a bad thing. Now, on the other hand, there is perhaps something of a case for concealment that's worth considering. Work product analysis suggests that a case can also be made for privilege here. The interest to be protected, it would be argued, is something similar to that described with respect to the lawyer's work product. There is, it can be argued, a strong interest in providing the expert, like the lawyer, with a zone of privacy so that he can consider candidly and dispassionately the strengths and weakness of the case. Indeed, if all reports, both good and bad, had to be produced, then it's possible that there would be a disincentive to pay an expert to prepare a candid and possibly negative report, which you'd have to turn over to the other side. Such a rule of total disclosure might encourage unduly partisan reports and discourage careful, dispassionate formulation of opinion in technical areas. And this, of course, would not be conducive to adversarial preparation of the kind sought to be protected by work product analysis. Accordingly, by applying work product analysis, a case can be made in favor of a rule which would permit a party to conceal reports of experts he does not propose to call at trial, but which will require disclosure of experts' evidence that he does intend to rely upon. A limited rule of this kind, I suggest best explained by work product analysis, would protect the need for candid and dispassionate preparation, an interest which won't be infringed by requiring a party to provide details of expertise he does intend to call. Now, the new rules arrive at this very result. First, substantial changes are to be made to the scope of oral discovery. The relevant rule will provide that the findings, opinions, and conclusions of an expert relating to any matter in issue in the action are discoverable, although they were made or formed in preparation for litigation, unless the party being examined undertakes not to call the expert as a witness at the trial. So the effect of that is that expert evidence which is favorable and which is going to be relied upon must be disclosed on oral discovery, while the negative expertise which has been collected need not be disclosed. The rules also provide, as does the Section 52 of the Evidence Act with respect to medical reports now, that actual copies of the expert's report must be provided shortly before trial, where the expertise is going to be relied upon. So the net effect is that if you're going to call the expert, there must be disclosure both on oral discovery and by providing a copy of the report before trial, but that you can conceal negative reports and negative expertise. The new rule relating to medical examination of parties establishes a similar pattern. Here, I think you can say that the rules actually abrogate documentary privilege. The rules provides that a party to be examined must provide the other side, prior to the examination, with copies of any report made by a medical practitioner who either treated or examined the party to be examined in respect of the condition in question. But again, reports of doctors gathered for the purpose of litigation, which will not be relied upon at trial, need not be provided. So the plaintiff, before undergoing the medical examination, will have to provide any positive reports. In exchange for that, the party on whose behalf the examination is conducted will be required to provide the party examined with a report of the examination. So there's a disclosure, mutual disclosure of medical reports required under the new rules. Now, there's another feature of the new rules, which again I would suggest can best be justified by applying work product analysis. And these are the rules which provide that a privileged document or privileged information cannot be used at trial without leave unless not later than 10 days after the action is set down for trial, the party who claimed privilege at discovery abandons his claim and provides the document or the information to the other. The essence of work product analysis is to restrict the scope of privilege to those matters which are necessary to enable counsel to develop strategy and theory for the case without having his opponent looking over his shoulder, but to require disclosure of anything the other side needs to prepare for the trial. This balance of interests is, I suggest, reflected by these new rules, which forbid the use of privileged material unless the claim for privilege has been abandoned. The rule requires counsel at a point in the proceedings when the strategy should have been established to choose between using the material or continuing to protect the zone of privacy. If the document's to be used or the information is to be used, fairness requires that it be disclosed. On the other hand, if it's going to be concealed, fairness forbids its use at trial. Now, another area, this is something other than the new rules, where an important development has occurred, cutting back on the scope of privilege, is with respect to preliminary investigative reports and the emergence of the so-called dominant purpose test. This comes from the decision of the House of Lords in Waugh and British Railways Board. Now, although in my submission the privilege asserted in that case was in fact solicitor-client privilege rather than litigation privilege, the distinction here becomes very fine, and I think an examination of the case is warranted. Until that case, it had been consistently held that a claim of privilege could be maintained although the document concerned was written, prepared, or obtained for a variety of purposes, so long as anticipation of litigation was, and the phrase this case is often used, was a substantial purpose. The Waugh case narrowed the scope of this rule substantially by requiring that the party claiming privilege establish that anticipation of litigation was the dominant purpose. Now, the Waugh case itself shows how this shift in emphasis will be important, especially in cases involving large organizations which have established and routine reporting procedures. Waugh involved a report made after a fatal accident by railway officers. The evidence led to support the defendant's assertion of privilege established that the report had been prepared as a routine matter and that such reports were prepared for two reasons. First, to establish the cause of the accident and further the cause of railway safety, and secondly, to provide the board's solicitor, the defendant's solicitor, with information upon which advice could be tendered. The House of Lords concluded that as the report had a dual purpose, and as the evidence indicated that these purposes were of equal rank or weight, that the claim of privilege could not be upheld. Lord Wilberforce, and I should note that this was the heading on top of the printed form which the report was made. The form was headed this way: for the information of the board solicitor, this form is to be used by every person reporting an occurrence when litigation by or against the British Railways Board is anticipated. It is to be provided by the person making it to his immediate superior and is finally to be sent to the solicitor for the purpose of enabling him to advise the BRB in regard thereto. The House of Lords held, notwithstanding that form, the documents had to be disclosed. Lord Wilberforce considered the balance of interests, and he asked himself whether a privilege was necessary to encourage candor in these particular circumstances, the candor designed to protect lawyer-client relations. Against that, he had to weigh the competing interest of the due administration of justice. The report was made shortly after the incident. It contained witness statements and was probably the best evidence anyone was going to have as to the cause of the accident. Balancing these interests, Lord Wilberforce held, and the rest of the other members of the House of Lords agreed in separate judgments, that unless the purpose of preparing for litigation was either the sole or at least the dominant purpose, privilege could not be justified. The Waugh case, I suggest, is especially important where the production of internal corporate reports is sought. There, the issue is whether the maker of the document, speaking for the company, is truly motivated by a desire to relate the events to the company's lawyer to obtain advice. As I've said, that claim failed in Waugh because the maker of the report did not have uppermost in his mind the promise of confidence as the dominant incentive for being candid. He had equally operative motives in making the report, and accordingly, according to the House of Lords, solicitor-client privilege in such case was not necessary and should not be given. When the document is prepared not by someone within the organization but by a third party, presumably this dominant purpose test would still apply, although I would suggest in those cases that it will be much less frequent, even less frequent, to be able to protect the document because third-party reports are not often sought for reasons other than the contemplation of litigation in this sort of case. Now, Waugh, I think it's unclear whether, at the present time, you can't say Waugh is the law of Ontario. There are conflicting judgments. There's a recent judgment of Judge Shea sitting as a local judge which applied it. There are two earlier decisions, master's decisions, which refused to apply Waugh. They did so on the basis that existing Ontario case law adopting the substantial purpose test precluded them from doing that. On the other hand, the Waugh case has been applied in several other provincial courts at the appellate level. It's been applied in the federal court, and I would suggest that the reasoning behind the case is quite compelling and quite in keeping with the trend that I've traced in the other areas, namely reduce the scope of privilege to the barest necessity. So I would predict that the Waugh case will be approved and applied in the courts of Ontario. Now, I'd like to turn to another issue, and that is whether or not the privilege is a qualified one that I've been describing. I have been arguing that a description of the actual content of litigation privilege as it has been developing and as it will exist under our new rules is best captured by work product analysis. What remains to be seen is whether our courts will adopt a corollary, an important corollary, of the American work product doctrine, namely that the protection it accords is a qualified one, which will yield if sufficient cause in favor of disclosure is made out. In Hickman and Taylor, the Supreme Court emphasized that the protection from disclosure of preparatory work was not based on privilege per se, but rather on a policy designed to foster the orderly functioning of the adversary process. Where, in a particular case, the court said, that same policy would be fostered by disclosure rather than by concealment, then the court said, we shall be faithful to our policy and not to the letter of our rule, and we'll order disclosure. Mr. Justice Murphy, again, quoting Mr. Justice Murphy, explained it as follows. He said, where relevant and non-privileged facts remain hidden, non-privileged, he meant not privileged by solicitor-client privilege, remain hidden in an attorney's file, and where production of those facts is essential to the preparation of one's case, discovery may be had. But the general policy, he cautioned, against invading the privacy of an attorney's course of preparation is so well recognized and so essential to an orderly working of our system of legal procedure that a burden rests on the one who would invade that privacy to establish adequate reasons to justify production. In other words, the Americans take the functional, process-oriented policy which underlies the protection to its logical conclusion, and they say where pursuit of that policy would be fostered rather than frustrated by disclosure, then you order disclosure. And this result in the United States has been codified in the federal court rules, which in fact adopt basically the Hickman analysis, and they actually provide that disclosure can be made upon a showing that the party seeking discovery has substantial need of the materials in his case and that he is unable without undue hardship to obtain the substantial equivalent of the materials by other means. The rule then provides for a higher level of protection for the actual mental impressions, conclusions, opinions, and theories of the lawyer, saying that in effect that the document should be edited if that's possible. Now, as you might expect, this qualified aspect of work product the work product test has produced a considerable volume of litigation, and the American courts have had to wrestle with the problem of defining what constitutes substantial need. One issue, for example, that's emerged is the mere fact that you cannot replicate the spontaneity of a witness statement made contemporaneous with the event sufficient to overturn the prima facie protection. Some courts have held that it is, and that's a reason for requiring disclosure of such statements, but other courts have disagreed. In other cases, hostility or reticence of a witness to talk to one of the sides has been seen to force disclosure. Now, before I consider whether or not our courts are likely to adopt this qualified aspect of work product protection, perhaps it would be useful if I were to summarize at this point. A full statement of work product analysis might be described something like as follows. The core interest to be protected is the orderly functioning of the adversary trial system. To decide how that interest is to be fostered, a series of propositions and qualifications or refinements may be put. First, the adversary system posits that disputes are best resolved if there are two independent investigations, the results of which are presented at trial. Second, and by way of qualification on that, the adversarial nature of our proceedings doesn't preclude a healthy element of disclosure. Fair and orderly trial requires that the adversaries be informed of the case they have to meet, and therefore there's mutual disclosure of the fruits of the investigation, of these two investigations which have taken place. Third, by way of qualification again, the disclosure itself has to be limited to encourage the independent investigation to take place in the first place. To foster and facilitate investigation, this zone of privacy is created, the zone of privacy captured by work product analysis. This zone of privacy allows counsel to conceal thoughts, observations, impressions, and opinions. And fourth, and this is the last point that I was just discussing, this protection of work product, the protection of work product itself is qualified in exceptional cases where upholding it would make too thorough investigations impracticable because the material sought is otherwise unavailable. Now, I have argued that the new rules will take us to a scheme of discovery which is best described by the first three propositions that I've just described, and it remains to be seen whether our courts will adopt the fourth, that is, the qualification, which will allow, in exceptional cases, something which is prima facie privileged to require something prima facie privileged to be revealed. Now, the new rules do not indicate an intention to reach this result, but I would suggest neither do they preclude the courts from taking this further step. I would suggest that you can't discount the possibility of this argument finding favor. Adoption of the qualified protection would have a disadvantage, namely, it would encourage more litigation over what is and what is not producible. However, in light of the unrelenting trend towards more disclosure and the paring of privilege down to its very core, such a development would hardly be surprising. Thank you.
When the new rules of civil procedure are eventually proclaimed in Ontario, all of us are going to be indebted to a handful of people who've worked for many years to perfect them. And when the new rules are proclaimed, we will no doubt want to express our appreciation to those people. However, given the present actuarial tables governing life expectancy in this province, very few of us may be here to do so when the new rules are proclaimed. Among the very few people to whom we must express our appreciation is Professor Garry Watson. Working with the Honourable Mr. Justice Morden and a subcommittee of the Rules Committee, which was struck in 1980 or 81 for the purpose, Garry has taken the draft which Walter Williston's committee produced in 1978 and has turned it to a honed and workable code of procedure reflecting the best present thought on how to litigate fairly, fully, and in the best interests of the parties and of justice. Gary's involvement in the process by which these new rules have evolved commenced in about 1977, if memory serves. It was in that, 75, I believe, Garry, it was in that year that he was asked by Walter Williston, late Walter Williston, to serve as counsel to Walter's committee, which had been appointed by the Attorney General to revise the Code of Procedure in Ontario. Garry brought to that task an expertise which he derived from a close association with procedure here and elsewhere. He taught at Osgoode Law School since 1966, as well as teaching at University of Southern California and elsewhere. He's always had an interest, a pronounced interest, in the law of civil procedure, and his knowledge in that area is now encyclopedic. After working with the Williston Committee and producing that draft report, which was submitted in '78, Garry was then asked to assist in Mr. Justice Morden's efforts with the subcommittee to perfect and, as I say, to hone Walter's proposals. And Garry will give you some indication where that process stands now. It's my great pleasure to introduce him. He is, as many of you know from your awareness of his trial advocacy programs and other efforts in legal education, a man of infectious enthusiasm and engaging charm, as well as being a superb legal scholar. I give you with pleasure Professor Garry Watson.